Hello, Louis. Great to see you. Thank you for joining, Professor Louis Franceschi.
Hello.
Hello.
Thank you.
Thank you. So on behalf of, I'm not taking much of the time. We have 4 speakers today. So on behalf of Institute of Law in my university, students and faculty wholeheartedly welcome all our 4 distinguished speakers of the day. Thank you so much. Over to Shreya.
Thank you so much, ma'am. Without taking much time of the audience, I would quickly like to introduce our speakers for today. We have with us Professor Louis Franceschi, who is currently the Senior Director of Governance and Peace of the Commonwealth. Sir is in charge of judicial transformation, the promotion of democracy, human rights, rule of law, legal education, elections, and good governance in the 53 member countries of the Commonwealth. Professor Franceschi is also the founding director of Strathmore University Law School, which today is regarded as one of the most reputable and innovative law schools in Africa. As a thinker, educator, and writer, Professor Franceschi loves positive and disruptive innovation. Sir is currently engaged on the Courts of the Future initiative, where he has brought together academia, practitioners, governments, and judicial officials to transform the way justice system operates in Africa. We welcome you, sir, and thank you for accepting our invitation. Next on the panel with us is Professor S.K. Bhatnagar. Professor Bhatnagar is presently the Vice-Chancellor of Dr. Ram Manohar Lohiya National Law University, Lucknow. Professor Bhatnagar has a long teaching and administrative experience. Sir has served almost for 4 decades as a law teacher in different universities and law schools. He was also the member of the first academic council of the National Law School, Bangalore in 1987. He has been nominated by the Chief Justice of India as the member of the Executive Council of the Indian Law Institute in 2006. Based on Sir's long teaching and research experience, he has contributed in many reputed institutions of national repute as member of their academic bodies. Professor Bhatnagar has also published around 3 dozen papers in reputed journals and edited books, and he has been a member of editorial and advisory boards of reputed law journals. Apart from these, he has also been invited by the All India Radio to deliver several talks on legal and other issues. Sir's special interests include legal aid and legal literacy programs. Thank you, sir, for joining us today. I would now like to introduce the audience to Professor Emanuel Towfigh. Professor Towfigh was Dean, EBS Law School, University, Professor, Chair in Public Law, Empirical Legal Research, and Law and Economics at EBS Law School, and also Professor of Law and Economics, Department of Management and Economics, EBS Business School, EBS University, Weisbaden, Germany. Professor Towfigh is also the Dean of the EBS Law School. He has also worked as visiting Professor of Law, Chair in Public Law, Public International Law, and European Law at Berlin and University of Virginia School of Law. Professor Towfigh is a profound scholar and has significantly contributed to several books, journals, conferences, and workshops. Sir, we welcome you to Institute of Law virtually and hope we'll meet soon again. Now I would like to introduce the audience to Professor Nelson Dordelly. Dr. Nelson Dordelly-Rosales is presently European and Foreign Affairs presently involved with the European and Foreign Affairs for the Venezuelan National Assembly. He is responsible for tracking, analyzing, and providing advice on the full range of policy and legislative development at the European Union level. Formerly, Sir was the head of the International and European Law Department of Law-Vesalius College in affiliation with the Vrije University, Brussels. Before taking this responsibility, Professor Rosales was the director of the Sustainable Development and Human Rights Program run by the Law and Development Group of the Faculty of Law in the university. Sir's research interests include the role of law to assist countries in Latin America as part of the design and implementation of policies and reforms for growth and prosperity. I welcome you again to the campus, sir, virtually. And now we will begin the session. But before that, three protocols. I would request the audience to keep their cameras on and their microphones on mute. And please address your questions to me directly in the chat box. As moderator, I would put them across to our panelists. With this, I would now request Professor Franceschi to address the audience on his speech titled Human Rights in an Unequal World. Thank you, sir.
Excellent, Shreya. Thank you very much. Good morning, good afternoon, good evening, wherever you find yourself in the world. I'm speaking from Rwanda, where I'm currently chairing some pre-CHOGM meetings. CHOGM is the Commonwealth Heads of Government meeting taking place hopefully in June 21st, 2021, here in Kigali, Rwanda. And then I came for the preparatory meetings that are ongoing between now and July and June. Amazing country, incredible people, very good preparations, and we hope all goes well. So when I was asked for a topic, I thought of a little bit of a mixture between my academic background and the diplomacy world where I live nowadays, where I'm practicing as the Senior Director of Governance and Peace at the Commonwealth Secretariat. And I chose this topic because it's something that I had seen theoretically from an academic perspective before, and now in real time, in the real world, is something we live among the 54 countries of the Commonwealth and all the other countries across the globe. Human rights in an unequal world. And there have been recently quite a number of criticism regarding the evolution of human rights. There is an author, Samuel Moyn, perhaps some of you have heard of him, The Last Utopia. And he's one of the forerunners of the critique. And he argues that human rights only revealed itself as a relevant practice in the 1970s, and the global turn to human rights as a discipline was itself embraced as a kind of new religion after the disenfranchisement of utopias like socialism or anti-colonialism. So the arguments he makes are obviously quite provocative. International human rights lawyers regard the non-binding Universal Declaration of Human Rights and the European Convention of Human Rights, which were drafted in the 40s and the 50s, as the founding document of human rights law. However, Moyn makes it clear that the concept of rights, including natural rights, stretches back centuries. I mean, the rights of man, we remember the French Revolution, and well, for most of modern history, rights have been part and parcel of the battles over meanings and entitlements of citizenships. With the internationalization of human rights, Moyn finds that the state violations of political rights garnered an unprecedented attention due to human rights campaigns and a commitment to material equality that had dominated previous decades disappeared. So basically, the world focused on human rights, on political rights, to the detriment, perhaps, or the neglect of social economic rights in the discourse on the fight for human rights. So in its place, a market fundamentalism emerged as dominant force in national and global economies. So in place of a broader social and economic justice, we chose to make these human rights out, highest ideals. Now, there is much we can find to disagree with such authors like Moyn, but his observation of the last half of the century, the last 50 years, it's something that actually has happened. In Africa, for example, in the 90s, we saw international communities imposition of political rights on African states. This was a good thing, but at the same time, to suppress human freedom is to disregard human dignity. And bundled together with these rights was the neo-classical economic idea that the dominant force in the developing state is the market, and that state interventionism or the developmental state was a thing of a bygone era. So the resulting chaos was that, for example, the World Bank and the IMF structural adjustment programs that were brought to Africa, sub-Saharan states, well, is documented widely, and there is a misunderstanding of Africa that is shocking. There had been no existing social class in African countries that could effectively bear the weight of national development, leaving the state as the only agency for change. Now, of course, for the international community to forbid the African state from carrying out this interventionism function meant the creation of a vacuum which played out in a grotesque way during, for example, the AIDS pandemic, the HIV pandemic. And that pandemic found broken healthcare systems and not existent social welfare programs that could cushion the impact of the pandemic's devastation. This is something that, interestingly, we are still living with the current pandemic, where we have imposed somehow on African state social distance measures that cannot survive in an African state. Well, I mean, social distance is a concept that I live in London nowadays, and fantastically, people can live social distance. But when you think of something like Kinshasa or Lagos, or some parts of Nairobi or Kampala, and you tell people that they must live social distance, 1.5 meters between them all, of course, I mean, it can't follow. So there are parameters we apply across the globe, or when we say, well, lockdowns, you must lock down the whole country. But of course, these are people whose states have no cushion, no possibility to cushion the effects of an economy that doesn't subsist. So you are locked down at home, but you are dying of hunger in that home because you have to keep social distance and you don't have access to the hand-to-mouth economy that made you survive. An interesting, very interesting fact that a study was done in Kenya regarding M-Pesa, mobile money, which is the biggest mover of money across the country. It moved more money per day than the 43 banks put together. Well, M-Pesa is very much alive between 3:30 in the morning and 6 a.m. And then again at 6 p.m. to 7 or 8 p.m. So, well, but what happens? And people in governments thought, well, perhaps these people are laundering money at 3 in the morning. No, it turns out that was the ones we know as mamambogas, the ladies who sell vegetables. Well, they were getting little loans from M-Pesa at 3:30 in the morning, going to the market, buying vegetables, going around the houses, delivering those vegetables, putting food on the table for their children, their families, and in the evening paying back those loans. Of course, when you tell these people to stay at home, you are telling them to die of hunger. So the state in such places has a huge responsibility, and this would not be seen when we follow measures or impose economic measures or parameters built for other countries that are more developed. So ironic to most observers was the unrelenting insistence of political rights. So you, for example, you close down the economy, but you must have elections, you must have democracy, you must have all sorts of freedoms, which are certainly key in the developing of a society, but certainly there was no understanding of contextualization. And yet the international community was blind somehow to the egregious display of material deprivation and social and economic injustice. So to an African scholar of international human rights, therefore, Moin makes a formidable argument. In fact, while most of the world is consumed with political rights, social and economic rights feature ever so prominently in the African Charter of Human Rights and People's Rights in 1981. So today, the problem of inequality in the world perhaps is seen more clearly, and the pandemic has harshly, the current pandemic, brought to the fore existing inequalities within states. We could consider, for example, the discussion on vaccine distribution, and we are having a terrible problem across the Commonwealth because, well, there are countries, especially the small island states or small states, that will not get any access to the vaccine until 2024 at least. And for example, the Caribbean countries are trying to come together. There are 6 million people in total. That is negligible for the production, and trying to say, well, we are trying to come together so that we can buy the vaccines and get them. According to a Lancet journal report, high-income countries representing just 16% of the world's population have already taken at least 70% of all COVID-19 vaccines doses available for 2021. So in fact, a study by the Economic Intelligence Unit found that 84% of all the world's poorest countries may not have resources to enable widespread vaccination until 2024. And the absurdity is that unless we vaccinate the highest possible number of people in the world populations, well, the COVID virus will be with us and will keep on infecting people, and people will keep on dying regardless of their wealth, sometimes even regardless of their country of origin or where they live. So it's key that we have to reset and rethink our approach towards the state and from the state towards the people. For the international community, this is a time for pause and contemplation. As Samuel Moyn states, human rights in an unequal world are simply not enough. What is the state's role in reducing inequalities? What is the international order's role in the promotion of social and economic justice? Well, the answer really is the demystification of the role of state in development, what neoliberal economics inculcated in the long accepting binary of an agile private sector and a lumbering inefficient state. We need to deny this, and the forefront of this school of thought is Mariana Mazzucato, an American-Italian, an impressive economist whose thinking is revolutionizing the idea of the role of the state, especially in the West. Now, the state has long been an underappreciated driver of growth and innovation. States function with very heavy bureaucracies, and sometimes we think that bureaucracy is opposed to innovation. Each of the components of the iPhone, for example, were funded by American state agencies. Siri by DARPA, GPS by the military, the hard disk drive, microprocessors, memory chips, and LCD display by the military, the internet by the Department of Defense, and the touch screen by the CIA, among others. So the question is not solely about the innovation of wealth, but really about the creation of wealth. And evidence shows that the state plays a fundamental role in this. And in many ways, here being in Rwanda, in the heart of Africa, for this week, I have seen with my own eyes, well, how important the state is in innovation, creating platforms for innovation. That's what they are trying to do this. I mean, it's an amazing country. The fact that Arsenal, the football team, has, as part of their propaganda, visit Rwanda is not by chance. The state is really thinking out of the box. So Mariana Mazzucato is advising governments across the world, and she's talking to both the left and the right because her ideas cut across the political ideologies. And it's not a matter of right or left. Her work has galvanized the European Union into adopting an ambitious program known as the Mission-Oriented Research and Innovation in the European Union for solving problems such as climate change. The idea of the state as an agent of change is vital, and the idea of the state as the primary agent to redressing the problems of inequality will be crucial going forward. So true human rights address the problem of material inequality. And the question does not involve decrying capitalism. It involves reimagining it and reimagining the way that society thinks about economic value. The relegation of the state as an investor of the last resort, as we have seen now with the COVID vaccine, as the agent of last resort that comes in to address market failure and is not involved in the liberation of solutions to state problems, has created a lethargic state, a state that is just dying in bureaucracy, becomes solely a regulator and cannot think outside the box, and an unequal society is created. Well, for us to reconfigure a more holistic conception of human rights, it is crucial that we redesign somehow the function of the state and redefine this purpose as a trigger for innovation and for change. Well, and these are, and with the redesign of the state, we have to redesign also international institutions, which were created as means for the state to connect with each other somehow, to communicate. And now this function has been widely changed by the media and by social media. So we have to rethink as well this function of international institutions as triggers to help the state somehow become real innovators and agents of change. So the honor, somehow the responsibility is on us and on each and every state and on each and every individual to push the state and to make sure that states are accountable, innovative, and agents of change as they should be, which is something we usually do as well through the vote and through the political rights we began talking about, but without forgetting the essential economic and social component every state has to fulfill in this regard. And with these remarks, sorry, I don't know if I passed the time, but I want to leave it here and I give the floor back to Shreya. Thank you very much.
Thank you so much, Professor Franceschi. And I believe one of the key takeaways is that a one-size-fits-all approach cannot be taken by states in times of the pandemic and otherwise also. With this, I would now like to invite Professor Bhatnagar, who will speak on comparative human rights and judicial legitimacy. Sir, over to you. Thank you.
Thank you very much. Good morning and good afternoon, honorable co-panelists, organizers, faculty, and participants. I've chosen the topic comparative law and judicial legitimacy. What is the purpose of comparative law? It is very useful when law is being made. For example, we are making data protection law, so we can gain experience from other legislatures. I would be focusing on the judicial aspect of comparative law, that what is the utility of comparative law for judges. And most of times you will find that the comparative law can assist judges in the resolution of difficult questions. By difficult questions, we can mean hard cases, as Ronald Dawkins says. And in such cases, the judge is expected to build a theory of principles. It may be called as moral and political theory. And judge has to act like a craftsman, as an architect. And he has to draw material from other sources also. In the realm of human rights, the things are quite easy for judges. Why? Because most of the human rights instruments in the national jurisdictions are based on international human rights. So when there are difficult cases, I think it becomes necessary to look at solutions and approaches of judges in other jurisdictions. Now, why it can be done so easily? Because we find that there may be similar texts, similar words which have been used by almost all the human rights instruments in the domestic jurisdictions. But how they are to be interpreted and how the judges dealt with similar problems or similar issues confronting them or their countries. And when they take into account the material which is available in other jurisdictions, then they can very easily demonstrate the judicial legitimacy. Because a judge can be accused of going outside the four letters of law, because he can be sometimes accused of imposing his or her own personal opinion or political ideology. But if he's looking to different jurisdictions, so he gains a kind of a judicial legitimacy. And secondly, the judicial accountability is also established because it is towards law. And law does not mean only a legislation. It means law which is in the process of making, the legal material, the non-legal material, which is spread over outside the country also, like that we can say. It doesn't mean that he has to follow the foreign judgments and decisions. They are not binding. They are available and they can be utilized for arriving at good solutions, which are good for their own jurisdictions, because there cannot be right answers. So the problem would be with, a judge, what are the appropriate jurisdictions to draw, from where he can draw lessons? So he will have to choose. That is one thing. What are the appropriate issues in which he can take clues from other jurisdictions? And thirdly, that when there are so many social, political, cultural, legal differences, how to get guidance from other jurisdictions. That is one thing. Second thing is that he will have to satisfy the inner intellectual, you can say, class of judges also, and the subordinate judges also, about the mandate of the Constitution. There may be a question. Is there any express constitutional mandate to rope in foreign norms? If I get time, I will go to South African Constitution, where there is a mandate. The Human Rights Act of United Kingdom, where there is a mandate. So what we find that in the realm of human rights, the judges can have easy traffic. Now, what is the way out? And what are the problems? In human rights, we will find, on the one hand, there are certain similarities, commonalities, because most of the human rights instruments in the domestic confines have drawn inspiration from international human rights instruments. It may be UDHR, it may be covenants or conventions on rights of different peoples. So in a way, we can say that globally speaking, we shared a framework, a legal framework. And sometimes there are common questions also, for which we must look towards, or rather the judges must look towards other jurisdictions. If it is a question related to marriage, now it is not a common question. Or if Example, it is a question of Indian marriage, Hindu marriage in India, or even a Muslim marriage in India, the rights of Muslim women in India. It will be very difficult to get guidance from other jurisdictions. But there are some common questions, common strengths, like, for example, hate speech, that is freedom of speech and expression, abortion, the rights of LGBTQ. So these are the senses of similarities where there is a shared kind of a legal framework, and we can easily go into all these things, and we can draw inspiration, lessons, whatever one wants can be done. It doesn't mean that there should be convergence. Even for divergence, the material is available from the comparative jurisdictions. Then second thing is, on the other hand, we find that there are really differences in the text, in the language, in the words, in the culture, in the history, and in the institutions also. For example, you take text. Now, Article 21 of Indian Constitution says procedure established by law. And due process was rejected in the Constituent Assembly. But despite that, we have seen that how due procedure established by law has been interpreted to come closer to due process of law, despite the fact that there are differences in the language also. Then it depends upon the institutions also, how powerful or how independent that institution is. I think that the Indian Supreme Court, the Constitutional Court of South Africa, and the Supreme Court of United States of America, and other also, I'm not, excluding, just for examples I've quoted, they are quite free. Sometimes they are under pressures also. They are under pressures also. For example, today we see in India that the rule was that bail is the rule and jail is the exception. But now there is some problem in it, and it is because of the judges. Because what pressures are there on the judiciary also, I don't mean by that political pressures. There may be institutional pressures also from within. So what the judges have to do, they have to balance in the realm of human rights, I would say, the public interest against the individual human rights. And when it is being done, it is to be done in the domestic jurisdictions. Maybe there is a commonality of English language, but it doesn't mean that there is universal meaning for human rights. There are not right answers. So we have to keep into account the domestic peculiarities also, because on the one hand, if we hear that the rights, human rights are universal, we also hear that human rights are cultural specific also. They depend upon the cultures also. The same human rights will be available, right to, marry, available to a woman, not only in India, but Northern India, South India, communities and caste, you will see the different meanings, different answers are there. So universal meaning for human rights is not possible, but we have to find out the answers to fundamental questions of human rights. For example, you take abortion. For abortion, you will find that there are different answers, and all are garbed into rights, human rights. Right of a woman to obtain abortion. How it is interpreted in the United States of America, that may be more liberal as it is called, but we will find that it is more, liberal in India, so far as right to abortion is concerned. So what kind of balancing is to be done? The balancing is to be done between the right of a woman and, if I may call it, right of features. Now, India, there are problems. That is, right of a woman to obtain abortion, right of a married woman to obtain abortion, right of a married woman to obtain abortion without or with the consent of the husband. Because there have been cases in the Indian high courts where the married woman obtained abortion. Husband went to the court that how it is possible. It cannot be done because marriage is a kind of mutual arrangement. And when it is question of a baby or fetus, it is also mutually agreeable. So how the exclusive right can be given to married woman? Like that, there have been many problems. So even we know that these human rights, universal human rights, give us the what you may call universal values, human rights values, I may call it, but they are to be applied. So for that, we will have to, or the judges must look to different jurisdictions, not for convergence, I am again repeating, for divergence also. Secondly, we are not talking about a global framework. It is not possible. For example, we borrowed the idea of directive principles of state policy from Irish constitution. And we wrote in our constitution that they are non-justiciable. Despite the language, despite the similarities in the language, in the words, and despite the fact that globally they were on the same plane, I mean Irish and Indian constitution so far as the directive principles of state policy are concerned, even then when we look at the interpretation in Indian scenario, we find that some of the directive principles of state policy which were non-justiciable have been converted into a fundamental right. For example, right to education as a fundamental right. Likewise, right to property. In 1950, it was a fundamental right. It was a fundamental right. It was borrowed from the US Constitution. But our experience told us that we will have to remove it. And then it is no longer a fundamental right, like Canada has also rejected it. So what I want to say is that in the realm of comparative law or comparative human rights, it is not necessary that there should be convergence. So what are we looking for? We should see comparative law, so far as human rights is concerned, as a mutual cooperation, as a project of mutual cooperation. If I can quote Aaron Barak, comparative law awakens judges to potential latent in their own legal systems. In our own legal systems, there are potential words of fire. But if he looks at the foreign jurisdictions, then he will get information and some kind of illumination, enlightenment from there. And then he will realize that the latent heat is there in their own legal systems. And moreover, the comparative law also informs the judges about the successes and the failures by adopting a particular interpretation or a particular legal solutions. So through a comparative law, judges get information, enlightenment, guidance, inspiration, and confirmation. Confirmation that is related to legitimacy, that is related to accountability. So in all the countries, you will find that we have drawn inspiration from the positive law. As Dawkins says, body of principles. So we can remain positivist. There is no reason or there is no case for becoming a natural lawyer. We can follow HLA Hart, that rule of recognition says that the judges recognize law. What is law in the USA? The judges recognize. What is the law in Canada? The judges recognize. So that is official recognition. We can use that. And in that sense, comparative law can be used as a resource, as a material. As if you can recall, Savigny used to say that you make law out of the non-legal material. But this is all legal material I am talking about when we are talking about foreign judgments. You have to be positive. There is no problem in it. And lastly, I can say there are certain cases in India, because I am running out of time. In India, for example, if you can recall the Naz Foundation case, 2009 of Delhi High Court, it was completely based on the understanding of comparative law. Though it was overturned in Suresh Kaushal case. But then comes Nalsa case. It goes beyond that. And no higher court had done that earlier, that the LGBT people were recognized at third gender. Not only this, in India, they were asked to be, the judges asked, the court asked that they may be treated as the backward classes for reservation. And then we have Puttaswamy, Justice Puttaswamy case, privacy. In that also the foreign judgments were referred. Ultimately, Suresh Kaushal case was overruled. That was in Navtez. And again, comparative judgments were taken. If you can recall, Vishakha judgment, where a right to not to be sexually harassed at the workplace violates Article 14 and 21. The Supreme Court had taken clue from international instruments and foreign judgments also. Likewise, live-in relationship, euthanasia, privacy. There are so many, examples which we can give. But now my time is over. So my purpose was to just demonstrate that the comparative law that is in the realm of human rights can be used by the judges to get the right answers for their own domestic jurisdictions. There are no universal right answers, despite the fact the terms may be same: equality, liberty, and whatnot. Thank you very much.
Thank you, Professor Bhatnagar. Through your talk, and you have run us through various judgments and various ideas. And we do understand that in a truly global world, comparative approach leads to judicial legitimacy and accountability. And yet we need to find the localization of the law as well and not forget that. Thank you so much, sir. And with that, I would now like to invite Professor Towfigh to speak on new challenges for human rights in the digital age. Sir, please.
Yes, thank you very much. Thank you for the very kind invitation and for having me here. Thank you, my dear co-panelists and organizers, and thank you to the audience for granting us your time. This has been already a very interesting debate, and it's interesting to see that I think my thoughts in an interesting way will tie in well into this. I must say the motto of your series of talks is let noble thoughts come to us from all directions. And I think this is a great motto, and I've heard already from different directions great ideas, and in all humility, I'm humbled to share some of the thoughts that are prevalent here. And I apologize, this is a very Eurocentric view, if you will, but this is, law is still parochial, and I'm an expert of the law that I engage with on a day-to-day basis. However, I think, as we've heard in the two predecessors speaking here, that there are general threads that maybe can prove helpful in thinking about human rights and what can be there more noble than human rights in the prospect of law. So from my perspective, I'm talking about human rights in a digital age, but really digitalization is just my starting point. And I think it's one of the drivers of change in these days that pose new challenges of our thinking about human rights. But these challenges come from various different other avenues of life as well. But I'm taking this as a starting point. And what I'm going to talk about is three aspects. First of all, what is protected? So what are the human rights? Do we see changes in the subject matter, in the content of human rights through digitalization these days? Second aspect is who is protected? So digitalization is also a driver of globalization. We're talking of globalization for decades now, but just if you see how we're being together from all over the world in this virtual realm here, and with the traffic going through dozens and maybe hundreds of nodes, internet nodes all over the world, and secret services tapping into these conversations all over the world, possibly, you see how digitalization transforms maybe the content and the need for protection subject matter-wise. And the third aspect I want to talk about is who is bound by these human rights, right? So to get started, what is protected? I think what we see these days is a substantial transformation of the content of human rights. So as you see in this gathering, for example, and I mean, this is also a driver, Luis Franceschini has pointed to it in the pandemic, maybe, as we have to distance socially, we meet in virtual spaces such as this one, right? And therefore, one of the pertinent questions being currently debated in Europe and in Germany is there a human right to assembly, to digital assembly, right? So we no longer meet in large squares, or some of us do, but protest increasingly also gets organized on social media, on digital platforms. And the question is, are there specific threats to this kind of demonstration, of gathering, of assembly? And there is a broad consensus that, in fact, the human right to assembly does not only cover physical assembly, but can be extended to digital assemblies as well, right? And this, in some sense, also changes the character of the right, because it's no longer, again, the physical get-together and physical boundaries that are set, but it might be access to digital means that will allow us to partake in digital assemblies that get protected too, right? Because it's not just me going out to the street. To be able to take part in digital assemblies, I need to have some sort of access to the digital arena. And in some sense, the more important digital assemblies become, the more important access to, or digital access becomes, and the more challenging issues such as the digital divide become. And again, Lewis has alluded to the very fundamental inequalities, and these, in some sense, these digital questions and the rise of digital access comes with a larger digital divide, which in some sense increases the fundamental inequality that we see across the world. There are a number of other small or bigger challenges. So, for example, what we see, I mean, in Europe, the Catholic Church is still an important religious player. So in the realm of freedom of religion, for example, we see that there are virtual or online religious communities developing, right? So there is the so-called Church of Fun City, which is a true Catholic community, which is only existing virtually. And again, here, gathering, religious expression, they take different forms, and we need to find ways to protect these expressions and these forms of religious freedom and religious expression. One part where we all see that there has been tremendous change, and that will kind of allow me to transfer over to the two other points, is the freedom of expression, right? So we see freedom of expression has happened in the marketplace, if you will, in early days outside in the streets. We have had the freedom of press and the freedom of expression in the press. And nowadays, much of our expressions happen online, in social media and social fora. And the whole matters of hate speech, particularly, again, when you connect it to the freedom of religion, for example, has become very prevalent and has created new dichotomies and new challenges for the protection. Now, if you look at what has happened in recent days with Facebook in Australia, kind of banning certain contents on its platform in the pursuit of lobbying for legislation, or if you think also about the ban of Donald Trump from the Twitter platform, what we see is that suddenly, and that transitions over to my second question, who is bound by human rights? That suddenly we have new actors that become very powerful next to state actors, right? So if we, for instance, look at Apple, Apple's quarterly profits are higher than the combined market capitalization of all enterprises in Russia. So the quarterly profit is higher than the combined market capitalization. This quarterly profit is also higher than the net spending of many of our countries, right? And if we take money as a proxy for power, and if we think of human rights as limitations on power, then the question very naturally rises whether we don't need to limit this kind of power. Do we need to limit Facebook, Google, Alphabet, whoever it is? And when we think of limiting these powers or regulating these powers, obviously human rights are one approach. So nowadays, and in our overcome doctrine, we of course only think states are bound by human rights, right? Both internationally, but also on the national level. Private enterprises, companies, as well as individuals are the beneficiaries of human rights, right? So they can turn their human rights against their governments, against the judiciary, as Professor Bhatnagar has put it so lucidly. But one of the questions that might come up is, well, shouldn't these platforms, shouldn't these very powerful players not be bound by human rights as well? And this is indeed one of the big current debates that we're seeing in Europe, and particularly also in Germany, where the question is, legally, technically, will this not lead to confusion? Can an entity, can an individual that is entitled to human rights also be bound by human rights, or won't this lead to some sort of confusion? And we see that today. So a lot of, on the European level, the question has been a bit softened because there has been special legislation that in some sense translates human rights approaches into regulatory law. For example, we have anti-discrimination law. Anti-discrimination law, if you go by the book, you could very well have this be part and parcel of equality, right? And of the human right of equality. But you can translate this and bind private entities to non-discriminatory behavior. Now, in the German context, it's more difficult. In the German context, what we've seen is that, in fact, the Federal Constitutional Court has started to go down a path where it is likely that big enterprises might be bound by human rights if they are platform providers, right? So if they provide goods and services and platforms in a way that can be likened to the state or to government. And this is a very hotly debated issue. And in some sense, you could say the Federal Constitutional Court jumps in here because the legislature is not living up to their job. So the legislature would be well in a position to, in fact, regulate, I don't know, Twitter banning individuals from its platform, Facebook banning certain contents from its platform. But as the legislature has failed to do so, the Federal Constitutional Court kicks in. And I was very interested in hearing your take, Professor Bhatnagar, on how the judiciary works in these respects, right? So the judiciary kicks in here. The sole tool that it has are the human rights, and therefore it interprets the human rights in such ways that they also apply to the Facebooks and so on. Now, this is a very challenging, very difficult part, and my take is that we will see a pushback here, because in some sense we need also protection for these private entities through human rights. But on the other hand, again, from a very Eurocentric, very European perspective, this is nothing extremely uncommon. If we look back in history, we've had discussions, for example, about the church being bound by the human rights. And again, the idea is always, if we have powers or if we have structures that are parallel to state power, that are as strong, as important, as basic for human needs, and if there is an accumulation or a concentration of power, then we need to limit these powers. And one of the possible ways to limit powers in law, or the strongest way to limit powers in law, is through human rights. So that's what's protected, that's who is bound. Now, the third question is who is protected? And again, this also connects to the judiciary, because the question of who's protected is inherently bound to the question who can bring up a case court, right? Because you might be objectively protected by human rights. If you can't bring a case, then it's no much use to have this protection. And in fact, this is a third area where digitalization is challenging common ideas and common concepts. And I've already alluded to the example. Now we're all connected here through the Zoom platform. And I'm sitting in Frankfurt, and all the traffic, me seeing you, is routed through an internet node very close to my home here in Frankfurt. So much of European traffic goes through here. Now, as I said, secret services of different countries are tapping into this node. So although you're not, none of you or many of you are not subject to the German government will be infringing upon your, or is potentially infringing upon your individual human rights to secret communication, to free communication. They could potentially shun one of our streams here, and so on and so forth. So while under normal circumstances, it would be very difficult for any of you to have standing here because we're getting in a virtual realm, this is a very important additional topic to be considering, that digitalization in some sense expands and extends the reach of the human rights, and suddenly includes new benefactors that have to have opportunities and ways to channel their claims and to bring forward their claims in other jurisdictions. The internet obviously is no legal vacuum, so regulation is necessary to protect both the users as well as the platform providers. But we see that if you think about human rights as means and tools to regulate power, there have become, we can see new actors on the scene that are as powerful as government and state actors, and that we need to kind of take into account and take into our picture. In this sense, again, if I may come back to Louis Franceschi, I think it's right that we have to look at states, but maybe we also have to look at these private actors who have accumulated huge powers in creating a more just and more equal world. And just to close, this was not in my original manuscript, but listening to Louis, I thought, you know, one of the things that digitalization, among other things, maybe probably the megatrend of globalization even more so, but one of the things that digitalization is showing us is that really these boundaries that we have drawn are fictitious, right? So the problems we have, and the pandemic shows the same, right? The problems we have are truly global problems, and we can only tackle them globally. And if we see migrants moving back and forth, and then this is just a sign of the fundamental inequality that we see in the world, right? So, and I want to close by alluding to the works of Ayelet Shachar and William Cairns, who say, you know, at the end of the day, migration and these issues are just a sign for the fundamental global inequality that we see. And the borders that we draw up, the boundaries that we see, they are just ways to shun or to protect our wealth, right? And to none of these boundaries are there in reality. Nothing is drawn in the sand or in the land. And we still stick to very archaic or very old concepts such as citizenship, which are randomly attributed. And Professor Bhatnagar has alluded, I mean, not directly, but by the authors you've quoted, also to the veil of ignorance, right? And if we think about this, none of us has in any way earned the privilege to be put where she or he has been put. And therefore, we have to take this globality of our world much more serious, and we have to see that our problems can only be solved together, and that therefore approaches such as human rights have been thought from a very global and encompassing perspective. And again, I'm sorry for having gone over time. Probably I'm very grateful for your kind time. Thank you very much.
Thank you.
Thank you so much, Professor Towfigh. And that was a very enlightening and inspiring talk. Not only did you speak about traditional freedoms like that of religion and expression and assembly in the context of present digitalization, but also how we can be using human rights to address newer issues and challenges in terms of private players and how they might be disrupting the current state of affairs. Thank you so much for that. I would now request Professor Nelson Dordelly to speak on the human right to democracy in the times of the pandemic. Sir, please.
Well, first of all, thank you very much for the invitation. Thank you very much to all of you for organizing this excellent panel. To all the panelists and to everyone who is listening, thank you so much for taking the time to meet with us and discuss very important topics on human rights. My talk is going to be about human rights to democracy in pandemic times. Last Friday, at the 2021 virtual Munich Security Conference, Joe Biden was invited as the guest of honor, and everyone was anxious to hear his speech, as he was the first on the global stage. Well, he did not disappoint. Interestingly, he focused on one particular issue, democracy. He said, and I quote, "We're in the midst of a fundamental debate about the future and direction of our world. We are at an inflection point between those who argue that autocracy is the best way forward and those that understand that democracy is essential." End of the quote. You could hear the applause here in Brussels when that statement was delivered in Munich, as world leaders have come to the realization that democracy is essential for the fulfillment of our basic rights and freedoms. Our international global order, based on international law, has been built on a set of fundamental values. Democracy is at the core of values protected by the international human rights system. If you look at the United Nations Charter, perhaps the word democracy is not mentioned. Yet the opening words of the Charter said, "We the people," reflecting the fundamental principle of democracy, the will of the people as the source of legitimacy of sovereign states and the whole United Nations. Although one might argue, well, isn't the state sovereign to rule in their homeland without intervention of others? To those I say, the Universal Declaration of Human Rights is clear. When it defines the concept of democracy, as Article 21 says, the will of the people should be the basis of the authority of government. And this should be expressed in periodic and genuine elections, which should be universal and equal suffrage, and should be held in a secret vote. The same article says everyone has the right to take part in the government of his country, directly or through free chosen representative. Even further, the International Covenant on Civil and Political Rights lays down the basic of the human right to democracy when it elaborates on several rights that are fundamental for a democratic society to exist. And those are freedom of expression and opinion, freedom of association, access to public office, holding free and fair elections, meet in a peaceful assembly, free association with others, equality before the law. These are the specific components that build the concept of the human right to democracy. In fact, since the establishment of the Human Rights Council, several resolutions have been adopted highlighting exactly this. These sets of rights can only be exercised, can be only enjoyed under a democratic society. Yet, since COVID-19 broke out across the globe, democracy and human rights have grown worse in several countries. The Human Rights Foundation, for instance, says that 80 countries have actually worsened the protection of human rights. Government officials have taken the opportunity to engage in abuse of power, silences their critics, and weakening important institutions. The decline in democracy means the lack of accountable government, resulting in an increase of corruption, gross human rights violations, and conflict. Like poverty, hunger, and climate emergencies, the rise of autocracy has a consequence that is no other than citizens suffering. There is no doubt that the pandemic has brought a bunch of challenges, but nothing compares to the difficult challenge that is safeguarding the human right to democracy for all humankind. Don't get me wrong, autocratic leaders were on the rise before COVID-19 happened. But many countries were engaging with them without any accountability, and perhaps did not pay attention enough to their issues with democracy because there were other global problems. However, it is this global pandemic that we have seen now, how the rise of autocracy can affect all of us in this, what we can call a global village. The rule base of international legal system is under a clear threat. And that's why democratic leaders are sounding the alarm now. Let's explore a few examples of how, since COVID-19 happened, the human right to democracy has grown weaker and allowed the rise of autocracy. So for instance, freedom of expression, and we heard from many of our panelists that were talking about this issue. The pandemic has been perfect excuse for many leaders to attack independent journalism. Although emergency situation might demand extraordinary measures to protect public health, restrictions might not impede the free flow of information. In several countries, journalists covering issues of COVID-19 were arrested, and others have been reprimanded. According to Freedom House, 91 countries increased restrictions on the news media as a result of the outbreak. One could argue that given the paramount of importance of free information, especially in the middle of a pandemic, would not be limited. But that's not the case. Many government officials have exploited the crisis to adopt strict laws or executive decrees sanctioning the expression of information about the pandemic, using the word fake news. We have witnessed censorship and persecution in an unprecedented scale. The International Press Institute, for instance, monitoring free media around the globe, has documented 426 violations during COVID-19 pandemic across the globe, including arrest and criminal investigation of journalists, restriction of access to information, physical and verbal attacks, and censorship of new websites and other outlets, with the excessive call of fake news. Government officials have exerted control over content, revoked registrations of different outlets, suspended printed newspapers, denied press credentials, and limited independent questioning at press conference. This is definitely alarming. Another right that is key in the component of the human right to democracy is freedom of association. Under the strict orders of lockdown and quarantines, most citizens initially stay at home to avoid mass gathering. Within the lockdown, people were not able to come together to collectively defend their ideas. Yet over time, however, hundreds of thousands of people have begun returning to the streets to advocate for various causes, including democratic changes. The right to protest was almost banned or severely restricted in 100 countries. In some countries, acts of repression and arbitrary detention have marked the assemblies. Although strict lockdowns in several parts of the world were in place to protect the population, in other countries was the perfect excuse for authoritarians to hold their grip tighter on power. In certain countries, going publicly criticizing the government for the response on COVID-19 was dangerous and even life-threatening. The public health emergency cannot be used as a pretext to violate basic fundamental rights, especially free and fair elections. In the middle of the pandemic, many countries were in the process of renovating their leaders. But given the rapid onset of the pandemic and the idea to protect the health of thousands of citizens, postponements of elections happened in many places, but many were used in a way to unreasonably advantage one side. Yet, such moves frequently fail to meet democratic standards. In certain countries, new elections were not even scheduled. Others designated the electoral process to tighten even the authoritarian grip. Others used the delay of the election to suffocate the opponents, exposing them to difficulties, impossible ways to campaign, and to leave them pretty much in their houses. Let's explore a few examples of what I'm talking about in different countries. I will use three. There are so many, but I will only use three for the time that we are constrained. Venezuela, for instance, my own home country, has suffered an unprecedented erosion of democracy norms to the point that the UN fact-finding mission that came last year in 2020, concluded that there were crimes against humanity committed that are going to now be sent to the International Criminal Court. As a consequence of this erosion of democratic norms, one ruler, one view, the economy has gone completely down the drain. From expropriation to mismanagement to corruption, hyperinflation is the highest in the world, and consequently has forced more than 5 million migrants and refugees to leave the country, many by walking the same distance from Madrid to Copenhagen. Others not so lucky had drowned in the chaos of neighboring islands, all in an attempt to escape the devastating situation that we're facing at home. Now, COVID-19 has been the perfect excuse for Nicolas Maduro to strengthen his own power. The nationwide lockdown has largely threatened the ability to hold any type of demonstration. In show of force, the military is in charge of enforcing quarantine measures and overseeing hospitals. So large numbers of healthcare workers and journalists have been unlawfully detained for speaking publicly about the missing of supplies, the quality of the official information in terms of count, and the fact that we are not testing enough people. Between January to May of 2020, there were over 754 forced disappearances, including hundreds of abductions conducted by security forces without any warrant, just arriving in their cars and accusing someone for not following the COVID-19 rules and being immediately imprisoned. But those were the ones who were lucky, to be honest, because from the UN team that went to Venezuela to explore what was going on, they found out that more than 7,000 people were killed in security forces operations, what we call extrajudicial killings. This goes without mentioning the already 400 political prisoners that they were in place there because of they were political opponents of the regime. All without that then we have an election in December to renovate the National Assembly. And this occurred in the middle of the pandemic and with the regime taking more and more grip of power. So campaigns were completely banned. People were not able to go outside in the streets. And immediately the opposition couldn't run for the election because it was impossible to do it. So that allows the government to hold power and strengthen autocracy in Latin America. But then if we move now to in Europe, we have another example, which is Belarus. Lukashenko, for instance, has maintained his whole power for 26 years based on the legitimacy of his image as a benevolent father of Belarusians. He was seen as an invincible after keeping a stronghold of power for so many years. But in August of last year, even during COVID-19 pandemic, presidential elections arrived, and Lukashenko was facing a novice politician, a former teacher that took the place of her husband, who had been already arrested for being against the Lukashenko, and that's not that Stanislava Tinkoshova. This woman leader had become the biggest opposition threat to the Lukashenko regime in decades. The frustration of the Belarusians that in the middle of the pandemic, they had to go on an election process that it was obviously on one side, it sparked protests across the nation. And to this point, is one of the biggest protests it was seen the biggest protest in the country that is sparked even to Russia. But the crackdown of dissidents has been very brutal, from opposition in prison, members of the opposition in prison, the journalists also being in prison. But despite the brutal crackdown of dissidents, the protest is still alive. And most recently, 2 independent journalists have been arrested for reporting protests in Minsk, trying to silence and suffocating the rights of the people to express their will in the streets. Last but not least, we have Uganda as well, in Africa. President Museveni is one of the longest serving presidents in Africa. He and his national resistance movement came to power in 1986, and at the end of a 5-year war, and have led Uganda ever since. So more than 36 years. He actually imposed mandatory masks in May and been restricted lockdowns, who've been seen for the world as a good measures to protect the population. Yet, presidential elections were due last year, but had to be moved to January of this year because of the pandemic. But before election campaigns formally started, the authorities blocked the opposition meetings and rallies. They were enforcing the government measures to tackle COVID-19 security forces. At the same time, they were shooting civilians. Several have been killed and hundreds have been arbitrarily arrested in the middle of the pandemic. With that situation, it's really difficult to run for a free and fair election. Rather than to safeguard the democratic playing field and allow people to participate, the government in place has been really enforcing security and using the pandemic as a pretext to violate rights and clamp down on the opposition and, of course, the free media. In fact, the challenger of the election, affectionately called the ghetto president, a 30-year-old musician called Bobby Wine, that's his star name, who ran the election but lost, and he challenged the results, saying that the results were actually a fraud because due to the election, normally the internet was shut down, but the crackdown of dissidents was ramping and the limitations of international observation on the election was unprecedented. In fact, Mr. Wine was in a house arrest for several days just after the election results were given. Protests emerged and journalists were trying to cover the situation, but they were facing brutal crackdowns from the regime. So these three countries, what do they have in common, even though they're in completely different sides of the world, that despite elections occurring in the middle of the pandemic, the human right to democracy has been violated. The international community in the three cases has expressed in strong statements condemning the actions of the regime. And all of them in the three countries, the international community has said that they were not free or fair elections. As we're speaking right now, here in Brussels, two blocks from my house, they are meeting the foreign affairs ministers, the 27 member states, with the State Department, head of the State Department, Mr. Blinken. And the EU and the US are now in talks about how to defend democracy across the world. That's the main point of the agenda today. And then in May, we're going to see the Copenhagen Democratic Summit, and it's going to be opened by Joe Biden. And the first thing that he's going to talk about is democracy and how we can protect it across the globe. Despite quarantines, curfew, lockdowns, and many people being in prison and journalists not being able to broadcast freely, democracy is still a very important value. Public is still demanding to have democracy. Similar to human rights assistance that are fighting hunger in many places in the world, as well as international orchestrated actions that are working to decrease carbon emissions to tackle climate change, the international community must act to protect this human right. Freedom is fragile and requires constant cultivation. Democracy defenders must unite to protect basic human rights, as particular democracy. Otherwise, we can say that COVID-19 pandemic would not just be a health challenge, but a threat to our political and civil liberties. Thank you very much.
Thank you so much, Professor Dordelly. And what an enlightening talk, because democracy is the need, and we really need to save our political and civil rights, as you rightly said. And across the globe, public health emergency has been used as a shackle on democracy. So that is something that we really need to watch out for. And Professor Steve also has a very beautiful comment to tell us that how human rights is no more just an elective or a theoretical course, but we are really seeing the need for it in the current times. Thank you so much. With this, I now open the floor for question and answer session. And our first question is from a student of ours, address, and I would like Professor Towfigh to address this question. Uh, the student is Mr. Shah, and he asks that human rights violation is seen on networks and websites which are hidden behind and beneath the surface of the web in the form of deep and dark web. This also includes buying and selling of anything, including human beings, child prostitution, pornography, and also child trafficking. It is the largest, one of the largest source of criminal source for organizing criminal activities. How can these methods of abuses be stopped, taking into consideration that the users who access these are not even traceable and are jumping places through VPN?
Yeah, that's a very good and very timely question. And I mean, there is a big debate around these questions, obviously, in Europe too. And it's not phrased, and I think your question already kind of alludes to the answer. It's not phrased in terms of the theory of human rights. It's really a matter of practicalities, of how to technically reach these people and hold them accountable. So this is really a matter of criminal law practice. And at the same time, we have to be very careful, and that's where it touches human rights probably, that we can be in a position to cherish the freedoms and the immeasurable opportunities that digitalization has brought all of us, to be able to gather in the midst of a pandemic with, I don't know, 355 people in a Zoom sphere. And at the same time, crack down with the force of the law on those people who abuse this fantastic technological advances to their own private lowly benefits, right? So it's a very difficult question, very technical question, but I think it's very important for the state, and maybe that's the core take-home point from my perspective. It's very important for state actors to show their presence and the force of the law in the digital realm as well, to establish that their sovereignty in these platforms and areas as well, so that it becomes clear that there are no spheres where there is no laws, no lawless spheres, because this is really our co-human beings deserve protection everywhere, also on a digital realm. And last thought, obviously this always connects. I mean, if you talk about human trafficking, if you talk about child abuse, pornography, all of these things, there is a real world thing happening, right? This is not just happening in the digital realm. There is a real world event that accompanies it. I'm sorry, it's very vague, but I'm not a criminal prosecutor. I'm not very well versed.
But it does give us an idea of how to go about and thinking about the problem that is deeply penetrated now. Thank you so much, Professor Towfigh. My next question is to Professor Franceschi. And sir, you made a very thoughtful comment of how we need to redesign our international institutions while discussing the pandemic and the idea of change and innovation that needs to be brought about through these international institutions. If you could highlight a little more about the steps that can be done in this regard, that can be taken in this regard.
Okay, thanks a lot, Shreya. I think this would take us another 90 minutes, but we'll try to just put something very much to the point. A little change that you see big changes usually begin with small triggers. And I think there are some key triggers we have to make use of. So for example, at the level of international institutions, we are still pegged to the idea that we are conveners of dialogue between countries, which is true and is a very important function of international institutions. But at the same time, it is true that 150 years ago, when international institutions were originally founded as they are nowadays with secretariats and etc., there was no possibility of communication between countries. And therefore, the international institutions had that function. Today's social media, internet, has somehow filled that gap so that countries can communicate, people can communicate with each other without the need of a filter or a convener. And in that sense, what Emanuel brought up of the big giants, tech giants controlling the conversation is what used to happen in the past with international institutions. So how do we have to redesign ourselves? Well, I think we have to change our mode from simply a conveners of conversation to trigger actors. For example, that we devote ourselves to looking at every country member, assessing the needs, whether they are political, social, economic, technical, and going and acting into those specific areas. So we are no longer conveners of dialogue because there's too much dialogue in the world, but little action. We have problems of implementation. So if we look, for example, at a country, a small island state, well, their biggest problem perhaps are the rising sea levels and the levels of debt with no tourism and the collapse of the economy because of no travel, because most of them live off tourism. Then, of course, we don't need to talk too much about it. We need to do something about it. So we go to the solutions. So we have to be more than conveners of dialogue. We have to be solution providers. And at the same time, we need to help states to realize that they have to buy into this by becoming innovators. And by becoming an innovator, the state itself is an investor in innovation, and they will collect the fruits. I mean, they will actually get money from innovation and then reinvest it in further innovation. So that way the state will stop being a passive actor or a regulator, pure regulator, or a destroyer of innovation due to bureaucracy, but become an actor in actually pushing. And then this increases all the levels of living of the populations. And then, of course, you get an automatic somehow improvement in basic human rights. I mean, gosh, we have so many problems, trafficking of people, modern day slavery, financial money laundering, things that affect deeply the structure of the state. And then, of course, that we should not be focused on the exceptions and put all our energies there, which is necessary. But all the energies cannot go there because, I mean, the whole system could be collapsing, and we need to somehow put it together.
Thank you so much, Professor Franceschi. And this was really insightful as to how we can use international institutions as part of the system in solving the problem, and not them being the benefits, taking the benefits of the situation. I now have a question from a colleague of mine, Professor Talari. And this is a question that she has asked to all the panelists. I would request Professor Bhatnagar to answer this question first, and then Professor Dordelly, and then Professor Franceschi and Professor Towfigh. The question is that we see that there is gross inequality across the world, and the United Nations and the governments have been promoting human rights. Can we envision a universal currency to all the states to ensure human rights through economic equality? Professor Bhatnagar, if you could answer this first.
Okay, does it mean a currency in the sense of rupee, dollar, or?
I think it's a universal basic income issue. I think she must be referring the UBI.
If that is like that, then I don't think it is possible at the international level. Even in India, I don't think that it will be possible. India is a federation, and you have seen that how federations reacted during this COVID pandemic. Take, for example, United States of America, Donald Trump and the governor of New York, they were at wars. India could present a better example, not because it was a cooperative kind of federalism, rather it was compulsive cooperative federalism which emerged out of it. And there was more and more centralization of the powers at the federal level. So when we are talking about a currency which can be applicable all around the globe, I think there is no possibility of this in the near future. Thank you.
Thank you so much, Professor Bhatnagar. Professor Dordelly, if you could express your views on the same issue.
I completely agree with Professor Bernard. I think that that's exactly, it is really difficult in terms of practicality when you put it in that context around the globe. The pandemic has been the best example. The issue with vaccines now, how we're going to distribute vaccines and how it's going to be for the global north with the global south, how it's going to be interacting with these countries. Now they're putting forward this called COVAX system. So countries, wealthy countries can contribute so that other countries can access the vaccine. That too, as an example of a way that we can perhaps in the future consider a way to countries united and putting this forward to try to tackle the main issues that keep this balance between all of us. That must be addressed. I agree, it's a good question. But in terms of in practice right now, as the world is heading, I don't see it happening quite soon. But I think it's a good question, and it should be a topic to be debated across the globe and to be considered as an important topic to raise.
Right, right. So, and Professor Franceschi, what do you think about this issue?
Well, I think this is more or less the question I have been trying to to answer for a long time. I would just simply put across that we need practical solutions, meaning solutions that are good theories, but also good practice. I always believe that a good theory is the most practical thing, because actually it can translate itself into practice. With new currencies, we face the problem of regulation, who regulates them, who handles them, who has the power behind, that is not clear. I think it's a very difficult thing. We have seen it with the cryptocurrencies. I mean, they have become huge businesses and huge earnings for a few. Financial inclusion does not necessarily happen. But anyway, I still think that, yeah, the state needs to style up and somehow go through a redesign on their role regarding, yeah, innovation, thinking out of the box, which is something that in the past until now has been an impossible issue, an impossible mission. Yeah, I don't know if this somehow shed some light into the conversation.
Right, right, sir. Thank you so much for your answer. And now I would request Professor Towfigh to express his views on this.
Thank you. So I'm not very conversant with the UBI discussion, but I think, and I agree that we have to look to practicalities, but at the same time, I think it's the duty of scholarship to look far ahead as well. and to come up with ideas that maybe are not practical right now or in this way, but that kind of start a conversation. And I think in that sense, as I said, one of the important prerequisites, I think, is to understand that entire humanity is just one community, and that every human being has the same value and should have the same basic rights and the same opportunities to a good life. And that whatever we do with drawing up borders is just an artifact or a signal for fundamental inequality that we have to do away with. And I think this is something we have to embrace, all of us together, and then we will certainly come up with good solutions in the long run. And I think as scholars, it's our duty to really make bold propositions, even if they are not practical. Maybe I agree that we also have to find practical solutions, Louis. I'm totally with you there. But I also think we have to be bold and not be held back by the little individual interests that will push back on great ideas.
Thank you, Professor Towfigh. So while all our panelists agree that it's not a very practical solution right now, but at least it can be a starting point for a good conversation. And I think that is the purpose of law, that what we think might not be possible right now may be included in the law eventually. I would like to take one last question, and I would like to address this to Professor Dordelly. One of our participants asks that across the globe, there are many situations when there is some violence. There is a requirement of rule of law, certainly. But in these situations, many a times, human rights get diluted. And also, like you said, you mentioned the case of fake news, or we talked about religion, practice of religion, etc. So how do you think that this dichotomy and this balancing of rule of law and that of human rights can be done, especially in the current times?
Well, thank you for the question. It's a very interesting one and a difficult one. As I mentioned, heads of state and Minister of Foreign Affairs and meeting in these weeks discussing exactly that, how to balance the protection of health and how to keep everyone safe from COVID-19, at the same time respect rule of law and human rights. It is difficult. It actually, the pandemic has put the light on the situation that it was there before. We had seen issues of violence and as you mentioned, the looting of human rights, the protection of human rights. But now with the pandemic, the eyes of the world are now on this topic and how we can deal with it. Just as it happens in Davos, here in Switzerland, it was part of the discussion, then in Munich, and now today at the, what is it called, the Foreign Affairs Council here at the EU, and then later in Copenhagen. So it is a discussion that we're having at the highest level possible, how we can deal with this situation. And I believe I will try my best to answer that, give a more practical approach. I think we have the institutions in the international community. We have an international court. We have an international criminal court. We have certain institutions. We have the Human Rights Council. We have the UN Security Council. We have certain institutions across the world that are there or were created with that set of mind, how we can ensure that this right are being protected. It is difficult because we have the issue of sovereignty. As I mentioned in my presentation shortly, the issue that sovereign states will argue, well, this is, I'm ruling in this is my neighborhood pretty much, and I'm the sovereign, and I rule as I please. However, the world has changed since the adoption of the Charter of the UN and the Universal Declaration of Human Rights. And now more than ever, we're realizing that the world we cannot sustain ourselves if we are not protecting these specific human rights. So to give you a short answer, if we don't take seriously human rights, if we don't take these seriously and protect them based on the idea that they are part of the core values that makes law an important tool for the protection of basic rights, then the world will go on a different direction, and that direction is the one that we must avoid, where we are not being able to express ourselves, or we're not being able to hold public office, or to have even the certain freedoms of think differently. So I hope that I answered your question, but again, thank you for the question, and I hope that this inspires many of you who are listening to believe in holding the rule of law, to protect them, and to protect particularly human rights as a fundamental values.
Thank you so much, Professor Dordelly. And with this, we come to the end of the Q&A session. And I express my gratitude to all the panelists today, Professor Towfigh, Professor Bhatnagar, Professor Franceschi, Professor Dordelly. It was a very learning experience for, I can say this for all of us, for the various facets you have shown to human rights in the current times. Thank you so much for that. And I would now request our student representative, Mr. Akshat Mishra, to propose the vote of thanks.
After a matter-heavy and substantive session, we, the students of the Institute of Law, are indebted to all our knowledgeable guests. We express our heartiest gratitude to Dr. Luis Franceschi, Professor Dr. Subir K. Bhatnagar, Professor Dr. Emanuel Towfigh, Dr. Nelson Dordelly, for all their knowledgeable perspectives coming from varied standpoints that wouldn't be available if it weren't for your presence. Apart from that, I would like to thank Professor Stephen Barnes for his constant and unwavering guidance that they provide to our institute. They just left 15 minutes back to take another class for a few of our students, and that's one of their amazing traits as well. Dean and Director Professor Dr. Puvi Pokhriyal for her innovative initiatives that she takes for all of her students. Professor Shreya Srivastav for her commendable arrangements and supervision. And lastly, for all the students and faculties present who are extremely attentive and always present on all such moments. Thank you to everyone.
Thank you so much, Akshay.
Thank you, Bhatnagar sir. Thank you, Louis. Thank you, Professor Louis. Thank you, Emanuel. And great to see you, Nelson. Thank you so much. Thank you.
Thank you.
Thank you so much. Have a good day.
Thank you.
Thank you, everyone. See you
Thanks
soon.
a lot.
Thank you very much. Thank you.
Bye.